Welcome to EUPrivacyForAll, Session 16 on GDPR, Right to Data Portability, Article 18. Negotiations regarding portability targeted two articles, Article 15 and 18. European Parliament suggested the existence of a right to obtain from a controller a copy of the provided personal data in an electronic and interoperable format which is commonly used. Where technically feasible and available, the data shall also be transferred directly from a controller to another. This right shall be without prejudice to the obligation to delete data. Finally, European Parliament deleted Article 18. EU Council recognized a same right to obtain a copy. However, it specified that this right shall not apply where such copy cannot be provided without disclosing personal data of other data subjects. It provided also an Article 18 drafted away that was finally really close to the final draft. Finally, Article 18 lays down interesting provisions on the conditions for this right to data portability to be exercised. Let's share a caveat first. This right will apply only when the processing is carried out by automated means. But moreover, it will only apply in the case of two legal grounds, that is to say, consent or contract. The four other recognized legal grounds will not be a basis for this right to apply. The right to data portability can be split in three rights. The first is the one to receive the personal data concerning a data subject, which he or she has provided to a controller, and to receive it in a structured and commonly used and machine-readable format. It also entails a right to transmit data to another controller. Finally, where technically feasible, the right to obtain that the data is transmitted directly from a controller to another is specified in Article 18. Let's recall that this right to data portability shall be without prejudice to the right to be forgotten and the right to deletion. Finally, the right to data portability shall not adversely affect the rights and freedoms of others. Recital 55 of the GDPR recalls some interesting points. First, the fact that data controllers should be encouraged to develop interoperable formats. Second, the fact that the right to data portability should not apply where processing is based on another legal ground than the one of consent or in the frame of a contract. Additionally, it does not create an obligation for the controllers to adopt or maintain data processing systems which are technically compatible. Finally, in a certain set of personal data, more than one data subject would be concerned, and then the right to receive the data should be without prejudice to the rights of other data subjects. Other provisions in the GDPR are Recital 59, laying down that restrictions on specific principles and on the rights, for instance, of data portability, may be imposed by union or member state law. It is all the same regarding specifications and derogations. Finally, in Article 14.1ae and 14a2e, the controller shall provide the data subject with information to ensure fair and transparent processing on the existence of the right to data portability. Currently, the Directive does not recognize any individual right to data portability. However, Article 12b and c lays down a right to obtain from the controller as appropriate, the rectification, erasure or blocking of data when it does not comply with the directive, in particular because it would be incomplete or inaccurate. There is also an obligation to notify to third parties. What should accountable data controllers and processors get prepared for? First, bear in mind that the right to data portability applies only in the frame of a processing that would first be carried out by automated means, and second, be either based on the legal ground of consent or of contract. This right means indeed three rights. The one to receive the personal data concerning a data subject which he or she has provided to a controller in a structured and commonly used and machine-readable format. It also means the right to transmit those data to another controller, without hindrance from the previous controller. And it finally means the right to obtain that the data is transmitted directly from a controller to another where it is technically feasible. This right shall not apply in case of a processing that would be necessary for the performance of a task carried out in the public interest, or in the exercise of official authority vested in the controller, or if adversely affecting the rights of others. Data controllers should promote some interoperable formats enabling portability. They also have the obligation to inform data subjects about the existence of this right. They should finally keep in mind that member states can provide restrictions, derogations, or specifications regarding this right. What will be interesting is knowing more about the technical formats such as commonly used, machine-readable, where technically feasible, as precise and specified by EDPB or international guidance.